Today we are going to be looking at some more of the European Union's institutions. Let's start by looking at the European Commission. The European Commission represents the executive branch of the European Union and is the most European of all the Union's institutions, specifically tasked with upholding the interests of the Union. It is made up of commissioners, one from each member state, holding office for a period of 5 years. Each commissioner is responsible for a particular policy area, not unlike a government minister in charge of a government department. Commissioners represent the Union and should not demonstrate any national allegiance when carrying out their functions. The Commission is staffed by a civil service referred to in Brussels speak as a fonctionnaire. The powers of the Commission are as follows. The first power is the power to propose legislation. As the Union's executive power, the Commission is responsible for proposing legislative initiatives to both the Council and the Parliament. However, the Commission's power of initiative is limited. Pursuant to the principle of subsidiarity, it may only make proposals for the adoption of legislation where the matter in question cannot be dealt with effectively at member state, national or regional level. As part of the legislative initiation process, the Commission sometimes issues a green paper setting out the purpose behind the adoption of the legislation and requesting interested parties to make suggestions and offer comments. Thereafter, having consulted with interested parties, the Commission may issue a white paper setting out its policy in a particular field prior to adopting actual legislative proposals. In order for a proposal to be adopted, a simple majority of commissioners is required. The European Commission also plays an important role in the enforcement of the application of EU law. The European Commission is said to be the guardian of the EU treaties and is empowered to ensure that each member state respects the provisions of EU law. Pursuant to Article 258 of the TFEU, the Commission may decide to prosecute a member state before the European Court of Justice should it consider that a member state is violating EU law. Article 258 proceedings are lengthy and frequently a negotiated settlement is found between the Commission and the member state in question. Thus, actual Article 258 hearings before the Court of Justice are quite rare. Before beginning a court action, the Commission will first contact member state by letter, outlining the problem and requesting the member state to find a solution. However, should the matter come before the ECJ, the court may impose a significant financial penalty or fine on the member state until it agrees to bring its behaviour into line with EU law. The next power that the European Commission has is its budgetary power. The Commission is responsible for drawing up the EU's annual budget, which is then presented to the Parliament and the Council for adoption. The Commission also manages the expenditure of the money budgeted for the different EU agencies, EU member states and regions. The final power of the European Commission is that of its power to represent the EU at an international level. The Commission represents EU member states internationally in bodies such as the World Trade Organization, the WTO. However, in other international organizations such as the United Nations, representation is at both EU and national level. There is a feeling in some quarters that the power of the Commission is on the wane and that part of its role has been usurped by the newly created European Council made up of the heads of state. Although this may be partially true, in reality the tides of power ebb and flow in response to the specific challenges facing the EU integration process, and so it is not perhaps surprising that given the many economic and social challenges facing individual member states, that there has been a move away from the federalism represented by the Commission toward intergovernmental cooperation represented by the European Council. Now let's take a look at the Court of Justice of the European Union. Judicial power in the EU is exercised by the Court of Justice of the European Union, the ECJ. The role of the ECJ is to interpret and apply EU law. The Court is only empowered to apply EU law, and its jurisdiction does not extend to Member State national law matters. The ECJ is made up of a number of different courts: the Court of Justice, the General Court, and the Civil Service Tribunal. The ECJ is made up of judges from each Member State, and both the Court of Justice and the General Court normally sit in chambers of 3 to 5 judges. The Court of Justice only sits in plenary sessions for important matters involving the Member States. The judges of the Court are assisted by 8 Advocate General, or AG. The role of the AGs is to present the Court with an impartial, non-binding legal opinion on a matter before it, prior to the Court actually rendering its own judgment. The opinion of the AG is only required where a new point of law is under consideration by the Court. The Court of Justice has both first instance and appellate jurisdiction. The General Court has first instance jurisdiction over cases brought by private individuals, companies and organisations, and also has jurisdiction in competition law matters. Finally, as its name suggests, the Civil Service Tribunal has jurisdiction over matters involving EU institutions and their employees. The role of the different courts making up the European Court of Justice is to apply EU law both at European Union and domestic level. Moreover, specifically, the jurisdiction of the ECJ extends to the following matters: actions against Member States for failure to fill an obligation arising under EU law. As we have seen, pursuant to Article 258 of the TFEU, the Commission is required to bring any Member State before the Court of Justice where the state has failed to fulfil its legal obligations. Another power of the ECJ is its jurisdiction over actions for annulment. Member States, the Council or the Commission may request the Court to annul a measure adopted by an EU institution if it is considered that it was not correctly adopted or if the content goes beyond the authority of the adopting institution. Action for annulment can also be brought by EU citizens personally affected by such laws. Another power of the ECJ is its preliminary ruling procedure. National courts of each Member State are responsible for the application of EU law provisions in their respective Member State jurisdictions. To ensure the uniform application of EU law by the different 28 Member State jurisdictions, the preliminary ruling procedure was created under Article 267 of the TFEU. Pursuant to Article 267, if a national court is in doubt as to the interpretation to be given a provision of EU law, it may ask the Court of Justice for a ruling on the matter. The ECJ will give its interpretation, which is then applied by the national jurisdiction when adopting its decision. Another power of the ECJ is actions for failure to act. EU law requires the EU institutions such as the Parliament, the Council and the Commission to perform certain duties. Should they fail to act when they are legally required to do so, under Article 265 of the TFEU, a Member State, another EU institution or a private individual may lodge a complaint with the Court. If the failure to act is considered to be unlawful, the institution in question will be required by the Court to correct its behaviour. And finally, the Court has the power to hear direct actions brought by private citizens. Pursuant to Article 268 of the TFEU, any person or company who has suffered loss as a result of the action or inaction of the community or its staff may bring an action seeking compensation before the General Court. Apart from the five main institutions, there are also other institutions and bodies essential to the day-to-day running of the Union. There is, for example, the European Court of Auditors, or the ECA. The ECA was established in 1975 and its role is to audit the EU finances, ensuring that the EU citizens get value for their tax euros. To a certain extent, the ECA is a toothless tiger insofar as it has no powers of its own and can only report its findings to the other institutions and member state governments. There is also the European Central Bank. The European Central Bank, or ECB, is responsible for the management of the Union's currency, the euro. Its functions include 1. The maintenance of price stability in the member states that have adopted the euro. 2. Working with euro member state central banks to ensure financial stability in the euro system. 3. Setting interest rates applicable throughout the eurozone or euro area. 4. Promoting financial cooperation and economic convergence in the eurozone. There is also another EU institution called the Committee of Regions. The Committee of Regions is an advisory body representing local and regional authorities in the European Union. The role of the Committee of the Regions is to represent regional interests in the legislative process. Moreover, the Commission, the Council and the Parliament are required to consult with the Committee of Regions before EU decisions are taken on matters concerning local and regional government. There is also the European Economic and Social Committee, ECOSOC. The European Economic and Social Committee, or ECOSOC, allows representatives of the EU's employers, workers and farmers' organisations to communicate their views to the Council, the Commission and the European Parliament at the moment legislative initiatives concerning the internal market are being proposed and discussed. There is also the European Investment Bank. The European Investment Bank, or the EIB, is owned by the 28 EU member states. It borrows money on the capital markets, and its function is to then lend that money at low interest rate to finance projects that improve infrastructure, energy supply, or environmental standards both within the EU and in neighbouring or developing countries. And the final institution that we are going to discuss is the European Ombudsman. The role of the European Ombudsman is to investigate complaints against EU institutions, bodies, offices and agencies. As part of this process, EU citizens, businesses and organisations may complain directly to the Ombudsman where it is contended an EU institution, body or agency has broken the law or failed to respect the principles of sound administration, for example, by reaching a decision in an unfair or discriminatory way. We hope you enjoyed this introduction to some more of the European Union's institutions and agencies.